Welcome to my channel, All for Health with Jane. Family, we are on the AKA and Tibz Motswane murder case. Family, accused number 3. Accused number 3, when contesting against the state's affidavit or the state's version on the case, how he is linked to the case, we hear accused number 3 saying he does not have any relationship with Gwabeni, meaning he is distancing himself from accused number 4, who is Gwabeni. Remember, Gwabeni is the one who, it is alleged, he distributed the 800K among the other accused people. So he says he did not have any relationship with Gwabeni. He was never an employee of Gwabeni as a security guard. And another thing is, on the night AKA and Tibz were murdered, he says he was in hospital for a gun wound. Maybe let me put it in that way. So meaning, according to him, few minutes, not even an hour, few minutes before AKA was murdered, he was already shot in the leg and had to go to the hospital. So meaning, exactly at the time AKA was murdered, he was already at the hospital in the casualty. So family, let's just listen to this clip where his lawyer is explaining to the court, reading out to the court their contest statement. So let's listen.
This is on behalf of applicant 3.
3, Your Worship.
A.D. Mieza.
That's correct, Your Worship.
Right, it will be received into the record as Exhibit J.
It's not I, H-I. J, oh J, yes, because we don't use I. My apologies, Your Worship. If I may proceed, Your Worship?
You may proceed.
I, Eddie Siana Mayeza, major male, residing L028 Paula Crescent in Mlazi, and currently unemployed due to me remaining in custody for a lengthy period, awaiting my bail application, do hereby make oath and state as follows. The content of this affidavit falls within my personal knowledge unless the context indicates otherwise and are true and correct. Where I refer to legal principles, I do so on advice of and in consultation with my attorney. The state filed a opposing affidavit in answer to my affidavit in support of bail. I herewith file my reply to the state's opposing affidavit. I deny that I was employed as a security officer and or bodyguard by applicant number 4, Mr. Gwabeni. I was not employed by him and did not receive payments from him for sale. My apologies, Your Worship.
Your Worship, may I be excused, Mr. Nkwera will be here. I don't want the court to agenda. We're just answering to a call of nature, Your Worship. I don't want to delay the proceedings.
It is not alleged by the state that my co-accused and I are family nor friends. There is nothing before this honourable court to show that we have any relationship nor friendship. The alleged link between myself and my co-accused is alleged cell phone calls made on the day. This link is circumstantial evidence that seeks an inference of conspiracy to murder, attempted murder and murder. Inferences must be drawn from fact, and such inference must be the only inference sought to be drawn. See Maleba versus SA 226-214, 215, ZAFSHC 6119, March 2015 below. The excerpt of that is the inference sought to be drawn must be consistent with all the proved facts. If it is not, the inference cannot be drawn. The proved facts should be of such they exclude every reasonable inference from them, save the one sought to be drawn. If they do not exclude other reasonable inferences, then there must be a doubt whether the inference sought to be drawn is correct. The trial court will be asked by the state to consider all circumstantial evidence, which is all the state has at present, and from same drawn inference that I conspired to murder the 2 persons, further that I murdered Mr. Forbes and Mr. Motswane, and that I was in possession of a firearm or firearms at some stage before, during, or after the incident. Circumstantial evidence in respect of conspiracy to murder, attempted murder, possession of firearms is that there were spent 9mm casings on the scene of the incident. The presence of spent shell casings thus serve as the circumstantial evidence to infer that firearms were present and discharged. This is the inference the state is seeking to have drawn by this court and will be by the trial court. Such inference will be absolutely absurd, and I submit that no court would draw the sought inference. The state is at this time asking this court and will be asking the trial court to infer that there were firearms, that the firearms were capable of being discharged and were in fact discharged by myself or my co-accused on grounds that there are spent casings found on the scene. With reference to count 4 being unlawful possession of semi-automatic firearms, to wit 2 9mm caliber firearms or pistols, and that I have no license or permit to possess same. I am alleged to jointly possess same with my co-accused. The principles of joint possession is discussed in my founding affidavit, Exhibit C, and applies evenly. The state sought to draw the court's attention to the firearm for which I was charged in Malazi and due to stand trial in the latter part of this year. The state alleges that the said firearm is the firearm used in these offences and that there is a second firearm that same was not recovered. Count 5 refers to myself and my co-accused being in joint possession of at least 6 9mm live rounds of ammunition. I presume Umlazi Bekitema Case 138-423 is the reference to live rounds in this matter, the firearms sought to be linked to this case. Annexure 8 to my founding affidavit, the second and third pages, contains the charges referred to in Umlazi Bekitema Case 138-423 in respect of the alleged firearm linked to this offence as counts 1 and 2. Bekitema Case 138-423 refers to a firearm that is prohibited, serial number filed off, to wit a 9mm Star Norinco. This case refers to a semi-automatic pistol. No further description is given as to the make and no reference is made to the serial number being obliterated. It is not referred to as a prohibited firearm. Bekitema Case 138-423 refers to joint possession at count 1. The count reading, the accused did unlawfully and jointly have in their possession. The circumstances described by the investigating officer Parbu at page 16 of the transcript, lines 8 to 24, clearly speak of 6 other persons that were arrested for possession of the said firearm. This amplifies my submission that the joint possession is alleged. Had I been in personal possession of the firearm, I would have been the only person arrested for sale. Page 19 of the transcript, line 19 to 25, is material, in that the investigating officer corrects the presiding officer when she says, can you confirm, paragraph 5, that there's a possibility that the applicant before court is linked to 7 cases of murder? He states that the firearm is linked, to which the court replies, the firearm is linked, my apologies, and he confirms, yes, your worship. It is clear that the state is relying on the firearm in the Bekitema case being the same firearm that was used in the commission of this offence. Parbu was, however, not committed to linking me to any of the murder cases. He simply proceeded with possession and the state prosecuted accordingly. Had the firearm in the Bekitema case been positively linked to this offence, one would have expected the state to have added murder of Mr. Forbes and Mr. Motswane as counts 3 and 4 and added my co-accused in this matter as co-accused in the Bekitema case. This was not done. I submit that the Bekitema case stands frail at trial and the firearm in that case is not linked to this case, leaving the state without any firearms, just spent casings. Following the proposed thought process of the author of the charge sheets in both these cases discussed, one can then safely presume that the state wished to add a count of unlawful possession of ammunition based on the ammunition recovered in the Bekitema case. It is alleged that I was in possession of 4 live rounds in the Bekitema case. In this case, count 5 refers to possession of at least 6 live rounds. Joint possession of firearms and ammunition will not survive the court's scrutiny and most certainly not result in a conviction in either of these 2 discussed matters. I submit that this case therefore has no recovered firearms nor live ammunition. The state avers that presence, use and possession of firearms by the accused can be inferred from the spent casings found at the scene. This haphazard and ill-conceived submission by the state is clumsy and will most certainly not result in a value judgment by this court nor the trial court that the existence, presence, use and possession of a firearm capable of being discharged and was used by selected persons in the commission of alleged offences can be found to be proved or capable of being proved based on the presence of spent casings on the scene. Counts 1 to 10 rely on a firearm or firearms capable of being discharged, whilst the court would in all likeliness be advised that there is a possibility that firearms may be recovered in future during the state's address. At the time of my application, there is none. The state cannot seek to cure the lacuna in its case by adding further evidence during its address. This should have been done in its evidence being contained in its substantial affidavit filed as Exhibit G. Going back to the inference that the state is asking this court to draw, I submit that the Honourable Court is asked to infer that there were firearms, despite no firearms having been recovered nor in evidence. The presence of the shell casings cannot possibly be held to serve as an inference that there were in fact firearms that were in my possession. Evidence in the trial court would require would be the firearms that were recovered, tested, linked to the spent shell casings, and a bullet or bullets removed from the deceased that are linked to same. I submit that in the absence of the state being in the position to prove the existence of 2 9mm pistols in the commission of the offence with ballistic reports, and further that the same firearms are sufficiently linked to the incident, will not be capable of being proved beyond a reasonable doubt during trial. I draw the Honourable Court's attention to the submissions at paragraph 5 of Padbu's affidavit, annexed to the transcribed record in my founding affidavit, in which he refers to several cases, 2 of which are mentioned in this case. Berea 85-223, which is this case, and Mabel 26-5 of 22. Both are murder cases to which the prohibited firearm is linked, being a Star Norinco 9mm. Padbu himself admits that it is not me, but only the firearm that is linked to the cases. There are no counts of murder attached to my case for Bheki Themba, and further, I am alone. I alone am charged. There are no co-accused in this matter. I submit that the SAPS is attempting to marry me up to other cases through the one firearm that was allegedly found in my possession or on another occasion, which is the joint possession submissions. Even in the unlikely event of me being convicted for possession of the firearm, joint possession disallowing same, I submit that a conviction would not imply use nor possession of the same firearm at any other time, giving a voice to the other matters for which I am charged. At paragraph 28 of Exhibit G, the state alleges at page 11 that a comparison with the Bheki Themba case 138-423 was made, and 2 of the spent casings on the scene was linked to the pistol I am alleged to have been in possession of at the time of my arrest, for same on 24 April 2023. This is what links me to this matter. I stand by my submission supra and in my founding affidavit that it is very unlikely that I will indeed be convicted of possession of the firearm in the Bheki Themba case. This link stands on shaky ground and cannot be held to be a link at all. At paragraph 29.1, 2 and 61 to 63 of the state's opposing affidavit, it is alleged that I was called by a person, not a co-accused as we stand before court, to arrange a Mercedes and firearms. The Mercedes referred to was not alleged to have been robbed by me at any time. Arrangements were then allegedly made between myself and the unknown person that the Mercedes and firearms be delivered to the latter person at the M4 Jacobs off-ramp. After the incident, the Mercedes and firearms were returned to me. It must be kept in mind that one Mr. Ngobo is charged with the robbery of the Mercedes and not myself. The Mercedes was found abandoned and not in my possession. Mr. Ngobo is charged as the only accused for the robbery of the Mercedes. Submitting the cell phone records will show contact between myself and my co-accused that I was the person who arranged, delivered and collected firearms and Mercedes-Benz the day of this incident needs to be addressed. I annexed here to King Edward Hospital records marked KEH1 that shows that I was taken up at casualty at 2127 on 10 February 2023 with a gunshot wound to my ankle under file number 00413-063. The investigating officer has the document at page 1 of KEH1 in his docket for Bheki Themba case 138-423, pistol possession. It is apparent that the I.O. Pillay did not take this document into account when he proceeded to charge me. Perhaps he was unaware of same. There is the issue of cross-referencing the 2 dockets if they are linked in a manner alleged. I am unable to speculate as to why this information remained undisclosed to court, but other information was revealed. I was then admitted as an inpatient straight from casualty after being stabilized on 11 February 2023 around 1 o'clock in the morning, 12:30 at night, as page 2, Annexure KEH1. The document refers to the casualty file number, top right, OP number 00413063. It further confirms at page 2 that I was moved or referred from casualty. My ankle was absolutely shattered and I remained on crutches until recently. The time of the shooting incident was around 22:18 on 10 February 2023. By that time, I was admitted at King Edward Hospital casualty, my admission being 21:27, and moved to the ward as an inpatient from casualty on 11 May 2023 at Hoppers 12. I was therefore not capable of being on the scene at the time of the shooting, in a position to collect firearms and a Mercedes-Benz, and presumably hiding same as I was in hospital with a catastrophic injury. I could not have been of assistance during the incident, neither after. The Section 204 witness statements stand to be disputed by my attorney during trial if admitted in evidence, and the witnesses give evidence on same. I deny that I shot myself playing with a firearm, so alleged by the state. The state submits that it is in possession of Section 204 witness statements. I submit that the court cannot accept that the witnesses will indeed be testifying as same. Should these witnesses be one or more of my co-accused, as it stands to be by virtue of procedure, my attorney would be asking the trial court to warn them prior to giving evidence that immunity to prosecution for the admissions under oath at trial implicating themselves is not a right, but it is in the discretion of the trial court to extend and confirm same upon finalization of the trial. The basis on which a Section 204 witness is suggested is where a case is extremely weak. I submit that the Section 204 witnesses agreed in exchange for favour in some manner or form, which will be addressed during trial. It amplifies my submission that the state's case is very weak. Reference is made to witnesses in plural, letting more than one accused off the hook speaks to volumes as to the state's case. The state filed its affidavit and largely deals with the alleged Section 204 witness statements, setting out the content thereof in storyline with accuracy. It would be inappropriate to discuss the content of the statements herein, as the statements may be challenged during trial as follows. The document itself may be challenged by the accused during a trial within a trial, and may then be either ruled admissible or inadmissible, after which the statements would no longer be a consideration if they are inadmissible. The content would not be within the knowledge of the presiding officer. Should the content of the statement be challenged during this bail application, it will form part of the record and may be used against all the accused at trial. Disputing the content implies that the statements are deemed admitted or at least admissible during trial, as one cannot address the content of a document unless same is admitted in evidence. The Section 204 document will therefore by implication be admissible as evidence during trial against the accused, and content will be the only portion left to address during trial. I cannot address the submissions in the state's affidavit where it recites events as set out in the Section 204 statements. Looking at the storyline, it is evident that the information was obtained within the Section 204 statements and related in the state's affidavit as evidence linking the accused. It is not appropriate for me to render these documents admissible with a lengthy affidavit that speaks to the content of the statement. I therefore elect to reserve comment on the alleged 204 statements, so preserving the rights of those who are alleged to have made the statements. The only submission I am making in respect of the Section 204 content of the state's affidavit is that the statements may well be inadmissible at trial as stated above. The allegations made therein should therefore carry little or no weight at the time of my bail application. The above submissions speak to the fragility and weakness of the state's case during this application, and further the weakness of the state's case during trial should this matter ever get to trial. The state disputes that the pending matter in Mlazi deals with joint possession of a firearm. I am surprised that this issue is brought before this Honourable Court. I however annex a copy of the charge sheet, an annexure marked A for ease of reference. The annexure reads, the accused did unlawfully and jointly have in their possession a firearm. I humbly submit that the state's case is weak during my bail application, and the weakness or fragility of the state's case is accepted by courts as being exceptional circumstances. The interest of justice does not demand that bail should be denied, and exceptional circumstances exist permitting my release on bail, and pray to the above Honourable Court to grant me bail on conditions that the court sees fit. Despite me being unemployed due to continued incarceration, I submit that my family will be able to assist in paying bail, and I ask that the court grants me bail in the amount of 5,000 rand. So signed by my client, Your Worship. My client has read the affidavit Excuse me, understands the content and no interpretation is required if that may be confirmed, Your Worship.
Confirm the content of this statement, Mr. Mieza, and that it was read to you, you understood it before it is read into the record, as it was not interpreted to you. Thank you. The statement has already been accepted into the record and marked Exhibit J.
As the court pleases, Your Worship, that will be the case for the applicant 3, Your Worship.
Case for applicant 3.
Family, don't you think here we are now faced with another Senzo Meyiwa Meda trial where the state is going to struggle. It's not going to be easy for the state, to prove enough evidence that these accused people are the ones who committed crime. Now, accused number 3 says, I was not there. When AKA and Tibz were murdered, I was in hospital. In the comment section, let's talk about this. Just tell me, according to your understanding, what are we foreseeing here? And thank you very much for watching to the end. Please do not forget to like this video before you leave. Subscribe for my channel if you haven't done so yet. I love you, family. Thank you. Bye.